Are you first? Okay. Okay.
That is a lordship. Lordship, I'd like to mention item.
Yes. Yes, please.
Lordship, I'd like to mention item number 5, Lordship. On behalf of MSC Nahodi Lordship.
On behalf of,
Item number 5. If this matter can come up on 2nd November, Lordship.
Heard Mr. V. Zumumi, learned, sorry, heard Mr. V. Zumumi, learned government counsel. Also heard Mr. P.D. Runson, learned counsel for the petitioner, and V. and L. Likate Sanctum for respondent number 6. Mr. V. Zumumi prays for fixing this matter on 2nd of November,
Lordship.
to which learned counsel for the petitioner does not raises any objection, hence the prayer is allowed. Let this matter be accordingly listed on 2nd of November.
Lordship, there is an interim order.
The interim order shall continue till next day.
Lordship, I also beg to mention item number 2, Lordship, on behalf of Yangami Lordship. I pray that this matter come after 2 weeks, Lordship.
Heard Mr. V. Zumumi submitting on behalf of Mr. K. Angami, learned senior government counsel, and prays for listing this matter after 2 weeks. Mr. Muazzam, learned counsel for the appeal, and does not oppose this the prayer. Hence, the prayer is allowed. Let this matter be accordingly listed after 2 weeks.
Lordship, I have a single prayer for item number 4, Lordship.
4.
Lordship. After vacation, Lordship, let it come after vacation.
No.
Yes, Your Lordship.
Same order. In
On behalf of Yangami.
same order, in place of the petitioner's counsel, mention the name of Miss
Senti Younger, Your Lordship.
Mr. Senti Anger. After 2 weeks.
Obliged.
Obliged.
From the supplementary cost list for judgment, item number 7.
Mention is still.
Mention. Lordship, behalf of additional AG, item number 10, 11, 12, and 13. Admission. After Bucha break,
What is your name?
additional AG, Imdim Song,
Heard Mr.
behalf of Ajungli, Y Ajungli Sangha.
Heard Mr. Y. Jungle Sanctum, who submits on behalf of Mr. Im Song, learned additional AG, and prays for listing this matter after
Bucha break, Lordship.
2 weeks. The
Lord-
prayer. You have informed the other side, no?
Yes, Lordship, yes.
He also submits that he has informed the learned counsel for the review petitioner. The prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, again, hearing, item number 3. Behalf of additional AG, Imdim Song.
Heard Mr. Singh submitting on behalf of Mr. Im Song, learned additional AG, who prays for an adjournment.
Lord for the petitioners.
Mr. Senti Anger, learned
Joshua.
Joshua Seki, learned counsel for the
The petitioner.
petitioner does not object to the said prayer, hence the prayer is allowed. Let this matter be accordingly listed after puja vacation.
Item number 16, 17, and 18, Your Lordship. I am praying for upgradation, Your Lordship.
Upgradation, I thought you would be praying for adjournment. I was very happy to see you.
If Your Lordship, what I am proposing, Your Lordship, there are two problems are here. Your Lordship, in this matter, since it was fixed for admission
Will
here,
it be possible to complete it today?
today we will try.
How much time will you take?
2
hours, 2 hours.
Together 2 hours, that will be enough.
Together 2 hours.
Yes,
No, it will
So it will be over by first half.
yes.
No, not 2 hours.
No, you give me an assurance. If I see a probability of spilling over the hearing, then I will not take it up.
I think
If
today,
you assure
today,
that-
today it will be over.
No, today means, today is very long.
Oh,
You finish it before first half.
no, that-
Yes.
Then we'll take,
We can finish it.
then we'll take it up as the first item.
Yes,
Second item, first item is already fixed. We'll take it up as second item. You finish it
It
before
will
first.
spill over to second half.
No, don't split
I'll try.
because today is the,
I'll try.
Yes,
you are ready otherwise.
yes,
Okay,
Lordship.
okay, we'll take it up as second item
Okay, Lordship.
after Mr. Moazami.
For judgment, item number 7.
For reasons mentioned in this judgment, this court is of considered opinion that the respondent authorities acted beyond jurisdiction and beyond the mandate of provisions of Nagaland Village Councils Act, 1978 in replacing the name of present petitioner with that of respondent number 5 as a member of village council, as a village council member of Chuchurui Vopan of Koyo village. And accordingly, and therefore the impugned approval letter dated 2/8/2021, whereby the name of present petitioner was replaced by the name of respondent number 5 as village council member of Chuchurui Vopan of Koyo village is hereby set aside and quashed. And the selection of the present petitioner as village council member of the Chuchurui Vopan village council of Koyo village is, and subsequent approval to the said selection by the government is hereby affirmed and upheld.
Next.
For motion, item numbers 8 and 9.
My pleasure, Lordship. Lordship, I have a small prayer to make. If this item number 8 and 9 and item number 1 can be taken up together, because they are analogous matters.
Item number 1,
Yes, my lord.
okay,
Analogous matter, same grounds, but except in this item number 9, that bill application number 22, I have made an additional ground for bill, my lord, medical ground, my lord. And also I have filed an IA along with the bill application, my lord.
okay, we'll take it up.
Yes, my lord, the IA number 21 of 23.
Which will we take up first?
Item 5 may be taken up first, Your Lordship.
Item?
5. Yes, item 5 and 7 are to be
No, no,
clubbed together.
5 is
1, 8 and 9.
1, 8 and 9. 5
One,
is already mentioned.
Okay, okay.
1, 8.
1 and 8.
Which
1
one,
and 8.
which one should we?
1 may be taken up first.
1.
My lord, if it will be proper, the IA has been heard first, my lord. The IA number 21 of 23, my lord.
Okay,
My lord, this IA is filed under section 34 of the Human Immunodeficiency Virus and Acquired Immunodeficiency Syndrome Act 2017, my lord.
what is that?
And here in my prayer, my lord, I've enclosed the copy of the act in my bill application number 22 of 23, my lord. At page number 71, my lord.
Bill application number 22 of 23 is item number
9, my lord.
9. This IA is in item number 8. That means you are praying for taking up item number 8 and 9 first.
Yes, my lord.
Yes.
So, my lord, through this IA, I'm praying for suppressing the identity of the alleged accused. And also praying for conducting the hearing in camera, as the present accused is a person living with HIV.
HIV.
Yes, my lord. So I'm praying for suppressing the name of the accused instead of using the name of the accused. This honorable court may please to allow
What the law provides, that 34 provides?
to use these pseudonyms instead of the name of the accused. So I've mentioned the name of the accused as XYZ, my lord, and also to conduct the hearing in camera, my lord,
Okay,
and also restrict any person from publishing any articles which may reveal the identity of the alleged accused, my lord.
what section 34 provides? Show me.
Section 34 is at page number 71, my lord, of my bail application. Number 22 of 23. May I read, my lord?
Page number?
71, my lord.
Yes.
The first per section 34, my lord, I'm praying for suppressing the name of the alleged accused and also for conducting the hearing in camera. My lord, may I read out the section?
Yes, yes.
Section 34, in any legal proceeding in which a protected person is a party or such person is an applicant, the court on an application.
What is the definition of protected person?
Protected person, my lord, will
Is
be
it
a person,
Is it defined in the act?
my lord, it should be defined. It should be people living with HIV, PLHIV, PLHIV.
Protected
It is,
person means
it's in section
S, 2S.
2S, my lord,
2S.
yes.
Person who is with HIV positive, okay.
Yes, my lord.
What it reads, protected person is a, read section 34.
Yes, my lord. In any legal proceedings in which a protected person is a party or such person is an applicant, the court on an application by such person or any other person on his behalf may pass in the interest of justice all or any of the following orders, namely A, the proceeding or any part thereof be conducted by suppressing the identity of the applicant by substituting the name of the person with a pseudonym in records of the proceeding in such a manner as may be prescribed. That the proceeding or any part thereof may be conducted in camera, restraining any person from publishing in any manner, any matters leading to disclosure of the name or status or identity of the applicant. My lord.
Okay, okay. So you are suffering from HIV.
Yes, my lord.
Is there any?
Yes, my lord. I have enclosed all the relevant documents.
Where is the finding that you are
In my bail application at Annexure G,
page?
page number 51. 51, where I've consented for
No,
HIV
not
testing.
consent, the findings.
Yes, and page number 52, my lord. Page number 52, if my lord can come down, specimen is positive of HIV,
Okay.
1 antibodies, my lord, during my medical checkup. My lord. It has been revealed. And further in page numbers 53, my lord.
Okay,
The pharmacies of the district jail have already ascertained that
okay. Now what have you prayed for in the IA?
I have prayed for suppressing the identity of the alleged accused.
Okay, this has to be allowed, Miss Mere. You have any
No,
submission?
as far as the
I is
case was
concerned.
concerned.
Okay,
And also to conduct the hearing in camera, my lord. if
okay.
possible.
If no, if that is the mandate of the law, then we have to follow it.
Yes, ma'am.
Heard Mr. In item number 8. Your name is also not shown.
My name is Sophie, my lord.
In the cause list,
No, it's shown, my lord. At serial number 2, it would be S Rana and A Sophie, my lord.
heard Mr. A. Sophie, learned counsel for the petitioner. Also heard Ms. S. Mere, learned public prosecutor. This interlocutory application has been filed by the petitioner under section 34 of the Human Immunodeficiency Virus and Acquired Immunodeficiency Syndrome within bracket Prevention and Control bracket close Act 2017, praying for suppressing the identity of the alleged accused within bracket the petitioner in bail application number
22.
22
22 of 23.
22/23. And 22/23 to protect and safeguard the identity of the accused, who is a person living with HIV/AIDS virus, and also praying for conducting the hearing in camera. Stop. Learned counsel for the petitioner has brought to the notice of this court the provisions of section 34 of the which act?
The Human Immunodeficiency Virus and Acquired Immunodeficiency Syndrome Act 2017.
The Human Immunodeficiency Virus and
Acquired
Acquired Immunodeficiency Syndrome within bracket Prevention and Control Act 2017, which is quoted herein below, quote 34, which is quoted herein below. It also appears from the laboratory report of National AIDS Control Organization, which is annexed with the bail petition, that the present petitioner is found positive for HIV-1 antibodies. Stop. In view of the available documents, it appears that the present petitioner is suffering from is infected with HIV virus, and therefore he is a person and therefore he is a protected person within inverted comma, protected person within the meaning of section 2S of the said act, and is entitled to the suppression of his identity as well as other special provisions as provided under section 34 of the said act, aforementioned act. Stop. Learned public prosecutor, in view of the legal provisions contained in the said act, does not opposes the prayer of the petitioner. Therefore, this interlocutory application is disposed of with a direction to suppress the identity of the present petitioner in this bail, in this proceeding, in this proceeding before this court, and he shall be, for the purpose of this proceeding, he shall be shown as within inverted comma X in place of his, instead of disclosing his real name. The proceedings of bail application number
22 of
22/23 shall be held in camera. With above observation, this interlocutory application is disposed of. So when to take it up, we'll take it up
It can be taken up today itself, Your Lordship.
when, now,
No,
no, later on.
Le-
On 30th,
my lord, it can be taken up on priority basis, my lord.
what is your submission?
Case diary is already here. Your
Case diary is there.
Lordship. Yes, Your Lordship.
My lord, if it can be taken up today.
So how to, whether we exclude all others because, or we will,
Yes, my lord, that can be done and the live feed can be cut off.
live has to be, live streaming will be stopped
Yes, my lord.
and other lawyers have to excuse themselves or we have to go to chamber. What do you suggest?
My lord, you will be aware.
Live streaming may be stopped. Or we may fix another date. 30th.
It will be Monday, right after the vacation. I think.
No, my lord, if it can be taken up today. My lord, it will just take some few minutes. My lord.
Because we are all,
Because of the
Because
prayer of
it's-
the
okay,
It is suffering.
this is a priority case.
Yes.
after the vacation.
No, in numbers, my lord. It won't take much time, my lord.
Okay, let us take it. Live streaming should be stopped. And other members have to excuse themselves. Only the lawyers of the case would remain. Yes,
My lord,
whether live streaming has stopped.
no, my lord, it's still continuing.
No, live streaming has to stop.
Yes, ma'am.
Otherwise it will not be camera.
Yes, ma'am.
It will be reverse of that.
Yes, my lord. And my lord, I filed a sealed envelope only for the perusal of this honorable court, where the name of the accused has been reflected in a sealed envelope for confidentiality.
Whether hearing would be a long hearing.
No, my lord, you don't take it, please. Because, my lord,
Because today I have constraint of time.
Your
Yes, ma'am,
Lordship,
it won't take much time.
I'll be specific.
I have already completed my pleadings on the previous date, my lord. Just this additional new bill.
The live streaming has stopped. Yes, we can. The live streaming should be on now.
Yeah. Actually, it's on your.
Put it on,
I've informed.
put on the live streaming. Now, which item would be called?
Hearing item number 6. Since they're not here.
The cause list has gone along with it. My cause list has gone along with those papers. Can we start? There was a small matter of Mr. Moa Zamir.
Oh,
He had only 15 minutes or 10. Yes, if Mr. Moa Zamir may be called.
yeah.
And you have only time up to 1 p.m.
Well,
Both of
Yeah.
you.
yes.
It is sufficient
If
time.
he, because his submission showed that for me to, I'll be only basing on the law only. So,
Try to complete it. Otherwise, if we start once, then I have to keep it part-heard.
mm,
And if I have queries,
mm,
then we have to keep it
Mm.
in, you have to answer the queries in BC. We may do that also.
That also can be done.
We may keep it part-heard.
And BC also.
And in BC from Gauhati,
Mm.
on a fixed date,
Mm.
according to convenience of
Mm.
both the side.
mm,
Because this appears to be a complicated matter,
mm.
Yes, sir.
unless I am clarified on.
Yes, Lordship, yes, yes.
So with that
Mm.
agreement, we may proceed.
Lordship,
That
Lordship.
at 1 we will stop,
Mm,
and
Okay,
if you complete by 1, it is okay.
yes,
If it is not completed,
Mm.
then remaining part we will keep
By BC.
part hard, and we will hear by VC mode.
okay, Lordship, Lordship.
Okay, yes, Mr. Tiba form. You, Moa Jamir has completed his part.
Yes, my lord.
You have to answer on.
Yes.
Albert.
Yeah.
Mr. Jamir may be informed.
I've already informed. He's coming.
Yes, his submission was that the observation given in the writ petition
Mm,
is not binding because
Yes.
this is mere observation.
yeah,
That was his.
yes, my lord. So, my lord, before I made my submission, kindly, your lordship, may kindly see my affidavit in the possession.
One, two, three.
Yes, para 8 and 9. May I read, my lord?
Yes.
That para 8, that with regard to the statements made at para 9, 10, 11, and 12 of the writ petition, the answering deponent begs to state that on receipt of the representation, the respondent number 2 and 4 approached to the BNAR department by letter dated 11/12/2020 for further consideration and approval, since the petitioners were found suitable. However, in response to the representation forwarded the government by letter dated 2207-2021 conveyed the observation made by PNAR department stating that the state government has been present by the Gauhati bench of the Kohima bench of the Gauhati High Court judgment and order dated 3/8/2018 and order dated 7/2/2019 from regularizing the service of any contract or ad hoc employees in terms of OM dated 04/08/28. Hence, the employees under
This you are
social
reading para?
para 8, my lord. In my affidavit, my lord. Affidavit in the opposition filed on behalf of respondent number 2 and 4, my lord.
2 and 4.
Yes, my lord.
It is not there. Affidavit in opposition of 2 and 4. This is a different file. Yes. Right.
Para 8, yes.
Because of High Court's order,
Yes, my lord, here, the petitioner, they have submitted representation. And that representation, the respondent has already forwarded to the government. Since the respondent number 2 and 4 found that the petitioners are suitable, so they have forwarded to the government, but the government, they have observed that they are being restrained by the Kohima bench, that order dated 03/08/2018 and order dated 07/02/2019. That is the judgment and order passed by the single bench and the division bench, my lord. And your lordship may kindly see that para 9. Para 9.
yes.
May I read, my lord? That with regard to the statements made at para 13, 14, and 15 of the writ petition, the answering deponent begs to state that upon receiving several representation from the petitioners, the respondent initiated the subsequent proposal for regularization by letter dated 09/02/2022, dated 13/12/2022. However, by letter dated 28/03/2022 and letter dated 10/03/2023 had conveyed the observation of the PNAR that the respondents cannot be regularized considered in view of the order dated that same. Your lordship may kindly see the annexure, page number 8. Page number 8. That is the proposal sent by the respondent number 2 to the government level. Annexure 8. The page number 8, annexure 1. And annexure 3. These all are proposals sent by the respondents to the government level. However, my lord, by the lordship may kindly see the last page number 15. Page number 15, annexure 6. Page number 15, annexure 6. May I read, my lord?
Yes.
To the Director, Social Welfare, Nagaland, Kohima. Subject, proposal for approval of the recommendation of the suitability task committee an ex post facto recommendation of the screening committee in respect of 45 employees. Madam, I am directed to refer to the letter dated 13/12/2022 on the subject cited above, conveyed the observation of the BNR department. The matter has been examined and it is clarified that the conduct of suitability tests and scrutiny by the screening committee barely have any significance against the backdrop of the High Court judgment and order passed in WBC 154 K of 17 and the Writ Appeal number 16 K of 2018. So, my lord, your lordship may kindly see that judgment and order in the writ petition, page number 74. In the
Yes.
Bara 29. Bara 29 and the second paragraph. Relevant portion.
Yes.
There shall also have to implead all persons whose rights may be affected by the petitioner in view of the reasons stated above. This court finds that the present petition is not maintainable in its present form. The relevant sentence is the state respondents should not regularize any person if he has completed only 3 years of continuous service on contract or ad hoc basis in terms of the OM dated 11/8/2016 and the OM dated 04/08/2018. It is a direction, my lord. By language, it says that the state respondents should not regularize. Specific direction has been given to the state respondents. And in the judgment and order of the division bench, that writ appeal number 19 of 20.
What is the language used by division bench?
My lord,
What language has been used by division bench judgment?
here also it says that in that para 22, relevant para,
It is at page, it is, okay.
that the judgment is already
Separate.
placed before
Okay.
your lordship.
Para
Para
20.
22 in the please allow me to read all the paragraph. This only the short paragraph. As such, the direct impugn the decision of the learned single judge 08/8/2018 disposing of the writ petition 145 K of 2017 being not maintainable in the form it was filed, without dismissing the same on merit and granting liberty to the petitioners of the said writ petition to make a fresh challenge to the appointment of the impleaded respondents therein, other persons as per law. We are of the view that the learned single judge did not commit any illegality in directing the state respondents. Say,
What-
even yes, in directing the word, this division bench also use here the directing. The state respondents, the appellant herein not to regularize any person who has completed only 3 years of continuous service on contract ad hoc basic in terms of those office memorandum dated 04/08/2016 and 11/8/2016 noted above as the OM are found to be not in conformity with the law laid down by the Honorable Apex Court in the case of Uma Devi. So, my lord, here facts is not disputed. In fact, the respondent has tried to consider the petitioner case.
Only
However,
because of the observation.
Because of this judgment and order. Because in the single page, the division page and the single page has clearly directed, specific direction has been given. So in violating this judgment and order, the state respondents are restrained to consider the petitioner's case, my lord. And my lord, until and unless this judgment is caution set aside, we are helpless. Sorry to say.
No, whether single bench can say that the observations made, your submission is that it is not precedent.
Lordship,
It may not be treated as precedent.
exactly, Lordship. I have relied on the authorities, Lordship.
And A single bench may observe that the observation made by division benches may not be treated as precedent. That observation may be made.
Lordship.
No, what is your submission?
My submission is Lordship. Observation has been made, no doubt, Lordship, by the single bench as well as the Honorable Division Bench, Lordship. But the office memorandum, 2008 and 2016, operation of this two office memorandum has not been interfered, Lordship. It has not been questioned set aside. And so long as it has not been questioned set aside, it rightly or wrongly it operates, Lordship. Now, whether an observation can be treated as a precedent, Lordship.
No, on that you have made your submissions.
Yes, Lordship.
You have cited rulings also.
Yes, Lordship. And secondly, Lordship, even citing those Omadivi's judgment, Lordship, there are two decisions which I have relied upon. Directing to consider the cases, Lordship.
In spite of Uma Devi's.
Yes, Lordship.
Okay.
And it cannot be applied mechanically. That is the, Lordship, the specific observation made by the Honorable Apex Court. It cannot be used as mechanically, Lordship.
Okay.
And the latest Lordship judgment rendered in the month of July 2023, Apex Court, if he has completed 10 years, those are the judgments, Lordship. It's very clear, Lordship.
Which one is the last judgment?
Lordship will find it.
WPC 34/23. No, that
Lordship,
is
serial number 9 of my citations, Lordship. The compilation, Lordship. Serial number 9. This is Raman Kumar's case, Lordship.
Raman Kumar. Okay.
My lord, in order to consider the regularization, the petitioner's case, there should be a source of law. And that source which the petitioner are claiming that relief under, that's two source. That is Office Memorandum 2008. and
High Court has
2016.
given adverse observation.
Yes, that already met redundant by this honorable court. So unless it is caution set aside, and that specific direction has been given to the state respondent, mentioning that against as per this OM, the two OM should not be considered. That is the specific given by the state by the honorable court.
Even otherwise, if I may be allowed, Lordship, my prayer in this writ petition is limited only to the extent of dispose the representations by a speaking order, Lordship. That is only the prayer that I'm seeking by filing this writ petition, Lordship. The representation is pending before the authorities, Lordship. And they are under the impression that
In representation, you were not informed that your matter is yet to be, is not considered only because of the observations made by.
it was not informed at any
It is
point of time.
not yet intimated.
No, Lordship, at any relevant point of time, Lordship.
My lord, in the affidavit in opposition filed by the state, the state respondent is already considered because the state respondent has forwarded the matter to the higher level.
No, but they have to be informed
Yes.
that because of this reason,
Because, yes.
because of this reason, we are unable to consider your
Mm.
regularization. Then against that speaking order, they may approach,
Exactly.
they may
Lordship.
seek
Exactly.
judicial relief.
Exactly, Lordship. Those are just mere communication between the department and the government, Lordship. I was
You are not.
intimated. And I came to know it came to light only when the state has filed the affidavit,
In
Lordship.
affidavit only you can.
Yes, Lordship.
Heard Mr. Moazamir, learned counsel for the petitioner. Also heard Mr. E. Tiba from learned senior government.
My lord, I'm not senior, designated as senior, my lord. Government.
Learned government advocate. Appearing for respondent number 2 and 4.
Yes, 2 and 4.
2 and 4. Hearing concluded, judgment reserved.
If I may, Lordship, just one humble submission, Lordship. If an observation can be made that this poems
lord.
are not being interfered with, are not questions set aside, if that observation may be made, well, if
Yes, my lord, respond number 1 to 4. I'm appearing 1, 2, 3, and 4.
E. Tiba form for 1, 2, 3 and 4. Okay.
obliged, Lordship, much obliged, Lordship.
Much obliged.
Six, who is there? Another hearing matter is there. We may not be able to take it up.
Yes,
today.
Lordship.
Six, we are deferring. We will take up other matter.
Lordship. If it can be fixed some other day, Lordship.
Heard Mr. Moazami, Learned Council in item number 6. Learned Council for the petition.
Additional Lordship.
Also heard who is appearing for,
Mr. Moimchan, Lordship, Senior Government Advocate.
you inform Mr.
Lordship.
Let this matter be on prayer of Learned Council for the petitioner. Let this matter be listed after 2 weeks.
Lordship. Obliged, Lordship.
Mr. Chaudhary, I'm coming after within 2 minutes, within 2 minutes.
That appointment, it is not very important. I can see. Which one?
More champion, please, more champion.
This one, yes, no, no, this is more Jamia is petitioner. And more yes.
Thank you, I'm sorry for this. I am free and here. Thank you.
Itu kenapa ayu tabol, kenapa etika orang Islam pasti tabol lagi bahawa dan itu dia apa itu apa pun sama. No, for me the what I think is not important which we talk about very not the institution that not it is not about that. So what I feel is
Yes. Yes, Mr. Chaudhary.
May it please your lordship. Your lordship, there are two sets of matters here. The first writ petition is pertaining to only for registration of the FIR and transferring the investigation to CBI, your lordship. The second matter is in respect to the FIR. FIR, where allegation has been laid against me, your lordship, and investigation has been made and charge sheet has been filed. That is the second aspect of the matter, your lordship.
There, what prayer you have made?
That question of the charge sheet.
Washing out the charge sheet.
In one question of the FIR and criminal proceeding, the other subsequent, when the charge sheet came, I filed another petition for questioning of the charge sheet and the criminal proceeding. That criminal petition 5 of 2021 is relating to questioning of FIR and questioning of the criminal proceeding. And the criminal petition number 27 of 2022 relates to questioning of the charge sheet and arising of the same FIR and criminal proceeding. Your Lordship.
The supplementary charge, cause list. A copy of. Yes.
Yes.
Okay.
Your Lordship, here, lot of facts have been stated, documents have also come, both by me and that, because to explain the background of case, but those documents are not relevant here. That will be relevant in the other matter, Your Lordship. Here, actually, that's why Your Lordship take Your Lordship the prayer of the writ petition first. Then that is the scope of the petition will come, Your Lordship. That is at page,
No, I want.
prayer starts at page 33, Your Lordship.
Get a photocopy of the copy.
I'm taking the writ petition, Your Lordship. 11 of,
Yes. Writ petitions, facts, you have stated.
yes, yes. Facts are,
You have stated that.
facts are similar in both because subsequent facts are, I have stated, I'm not with the facts.
Okay.
I'm just, facts I have stated. Only thing, the scope of the writ petition, I have just, this thing, Your Lordship, scope of the writ petition is that page, Your Lordship will see, it is starts at page 33, Your Lordship, see? Page 33. Writ of mandamus or any other appropriate writ order direction of like nature should not be issued directing the respondent to register an FIR in respect of complaint dated 3/8/2018 and the Caesar memo dated 3/8 prepared by UBSI Lee Chang Thang Lothar. He was the commander of the commander who has seized the material at the checkpost, Your Lordship. At Kohima narcotic checkpoint, he is the person who led that team, and he has arrested those persons, seized those drugs and the vehicle, and brought it to the police station with this written FIR and Caesar memo, Your Lordship. Then second prayer is writ of mandamus or any other appropriate so and so, directing the respondent number 1 to give consent to transfer the investigation of the case arising of complaint dated so and so to CBI. Here you
First prayer is to
yes, register the complainant.
treat the complaint dated 3/8/2018 as FIR.
No, it has
Then,
not been treated as FIR, but it has not been treated as an FIR. It remains as a complaint.
but your prayer is to treat that,
To register as an FIR, treat it
register the same,
as
register
FIR,
same complaint as an.
as FIR, and along with the Caesar memo and investigation should be transferred to CBI, Your Lordship.
Okay.
That's the third prayer says, because second prayer is for consent of state that section 6 of the Delhi Police section 2 is said. Directly respondent to give consent of transfer investigation of the case arising of complaint to the CBI, Your Lordship. Then
Yes.
third prayer is transferring and registering the FIR CBI investigation and trial to state criminal case in the interest under the control of so and so. So CBI. Your Lordship, may I point out one thing? There are two. One is Section 6 of Delhi School Special Police Establishment Act, which says that consent of the state government is necessary and that is. Thereafter, the apex court by a constitution bench judgment has stated that court has power under Article 226 of the Constitution of India to transfer the CBI without taking consent of the state also.
Okay.
And there is a following that, I'll come to those judgment also. Following that judgment, there's another matter which was argued by me in Gauhati High Court earlier, Your Lordship, when Justice Ujjwal Bhaiya as he written one. There also, that transfer was made, that judgment also I am referring. Transfer was made to CBI, at the FIR registered at Gauhati, transfer to CBI. That judgment. So this. Now, Your Lordship will see. The complaint is there. Your Lordship will start at page 38. If Your Lordship, page 38. With reference to subject matter, I have the order to state that on 3/8/2018, at around 8:30 hours, one vehicle Maruti Swift white color registration number so and so was signaled to stop for checking by the duty personnel of Kohima narcotic cell checkpoint, but the vehicle accelerated and escaped from the checkpoint. Sensing something fishy, duty personnel intercepted the vehicle after a brief check. On checking up on the vehicle, the party recovered 11 packets of suspected brown sugar weighing about 6 kg, 900 grams. The illegal items were wrapped with brown and yellow tapes and concealed inside the extra special set of the back seat. In this connection, the two occupants of the vehicle, namely Sri Rahul Kharal, so and Deepak Lama, were apprehended and illegal items were seized. I therefore request your high esteemed authority to kindly register a case under approved section NDPS and investigation thorough. Then next page, 42 page 42, if your lordship see. This is a Caesar memo, your lordship. Caesar memo, if your lordship will see.
Acha, where is the
Yes, sir.
original copy of this complaint?
It
Is
is
like
there,
now?
original complaint, original complaint, it is in this.
Where it is?
It is in the record also. It is in the other petition.
No. You have already
Yes, sir.
already annexed the type copy also at page 37.
I just, this.
Whether page 37 is the original,
Yes, 37.
page 37.
Yes, your lordship. Original complaint.
In
is
which
there, is
record now, from which record you have found this?
Your lordship, it has, because what happened?
Because this was not registered.
Not registered. What
Where
happened?
it has gone? Where it is lying now?
It is a part of the record of the charge sheet also.
Against you?
D5 document,
Okay.
that is part of the
So
record,
this is on record.
on record also.
Okay.
They have not denied it.
Okay.
D5, D5 is that charge document by component D5, it is there. Both,
So this, the prosecution side is not denying that such a
no, they are
complaint.
not denying.
Okay.
Even in the affidavit, they have not denied. Affidavit, they have not denied anything. The issue is, then their Caesar memo is also, they have not denied. Caesar memo is this one. And it is part of D5, your lordship. D5, it is there, your lordship. Like this. Because it is in 20 volumes, your lordship. The whole documents are in 20 volumes and one charge sheet, there's another volume, your lordship. D5 is having that D5, this compilation D5 with that document. It is containing both the things.
Okay.
But unfortunately, in the investigation and the charge sheet, these are not considered, these are not investigated also. It remain in the record only, your lordship. So this is a Caesar memo, if your lordship will see. Property recovered on 3/8/2018, your lordship.
At page?
42. Page 42, your lordship.
Yes.
Your lordship will see it is FIR is not mentioned here. 3/8/2018. Property seized recovered date 9 AM. Kohima checkpoint. Accuses Rahul Kharel and other is two persons are there. It just seized from he the person who led to the recovery of this. That's why his name is already there. Deepak Lamba's name is not here. Rahul Kharal he's there. It is at his instance that the drugs are recovered from the vehicle. Okay. Rahul Kharal is there. His name of the first so and so. This original so and so. If you lordship, next page, if you lordship will see suspected brown sugar rapper so and so, signed by Rahul Kharal, your lordship. So,
Yes.
so now, if your lordship, see section 154 of the CRPC. Information to cognizable offense. Every information relating to commission of cognizable offense, if given orally to an officer in charge of a police station, shall be reduced in writing by him or under his direction and be read about the informant, and every such information, whether given in writing or reduced in writing as appropriate, shall be signed by the person giving it, and the substance thereof shall be entered in the book kept for such officers. Here, your lordship, the police officer is the complainant, your lordship. He has given the complaint and signed it. Now your lordship comes. It is a cognizable offense, and it has not been denied by them also. And if your lordship, I'll take your lordship to the Supreme Court judgment. Uh, 2014. It is regarding not registration of area. 2014 to SCC, page 1. It is a 5-judge bench decision, your lordship.
Lalita Kumari.
Yes, Lalita Kumari was the government of UP, your lordship. Here, your lordship, if I lordship take your lordship to page para 49, page 35, your lordship, para 49. Here it talks about this thing. I just consequently a condition that since gone on for recording FIR under section is that there must be an information, and that information must disclose a cognitive para 49, your lordship. Para 49.
Yes.
The conclusion is that for recording an FIR under section 154 of the God is that there must be information, and the information must disclose a cognizable offense. Here, lordship, there is no dispute that a cognizable offense has been made out. Since on that material another FIR registered, so cognizable that is not an issue here. It's an admitted. If any information disclosing a cognizable led to before an officer in charge of a police station satisfying the requirement of section 154(1), the said police has no other option except to enter the substance of thereof and the prescribed form, that is to say, to register a case on the basis of such inquiry. The provision of section 154 of the code is mandatory, and the officer concerned is the duty bound to register a case on the basis of information disclosing a cognizable offense. Thus, the plain reading of section 154 must be given its literal meaning. Your assistant, para 50, they use the word shall. The use of the word shall in section 151 clearly shows that a register intent that is mandatory to register an FIR if the information given by the police discloses a commission of cognizable offense. Then I take your lordship to para 54. 49, 50, then 54, your lordship. Therefore, the context in which the word shall appears in section 154(1) of the code, the object for which it has been used, and the consequence that will follow from the infringement of the direction to register FIR, all these factors clearly show that a word shall used in section 154(1) needs to be given its ordinary meaning on being section 154. Section 154 is the ordinary on being mandatory in character, your lordship. The provision of section 154(1) code read with the light of statutory scheme do not admit conferring any discretion on the officer in charge of the police station for embarking upon a preliminary inquiry prior to registration of the FIR. It is a settled position of law that if the provision is unambiguous and the register intent is clear, the court need not call into rules of construction. Next para is, in view of the above, the use of the word shall coupled with the scheme of the act lead to the conclusion that the legislature intended if an information related to commission of cognizable offense is given, then it will be mandated to be registered by an officer in charge of the police station. Reading shall, as may be contended as by many counsel, would be against the scheme of the code. Section 150 of the code should be strictly construed, to give his natural meaning. The golden rule of interpretation can be given a go by only in cases where the language of section is unambiguous and leads to absurdity. Then, your lordship, I take your lordship to para 57. It is contended by learned AAG appearing for the state of Chhattisgarh that recording of first information under section 154 in the book is subsequently entered the general diary. Here there is no entry into general diary, your lordship, station diary, daily diary, which is maintained in the police station. Therefore, according to the learned AAG, first information is a document at the earliest in the general diary. Then, if a preliminary interview is needed, the police officer may conduct the same, and thereafter the information will be registered in FIR. This interpretation is wholly unfounded. The first information report is in fact the information that is received at first point of time, which is either given in writing or reduced in writing. They have rejected that. It is not the substance of it which is to be entered in the diary prescribed by the state government. The term general diary, also stationary in some cases, is maintained not under section 154 of the code, but under section 44 of the Police Act 1860 and the states with the president. Here, Lordship, section 44 of the Police Act have been extracted in the petition itself, Your Lordship. That is at page. That is at page 19 of the writ petition, Your Lordship. It's nice. Then page 20 is the section 24, Your Lordship. See? Page 20, section 24. My Lord has got it. Page 20.
Yes. Yes.
It shall be the duty of every officer in charge of a police station to keep a general diary in such form and shall from time to time be prescribed by the state government, and to read therein all complaints and charges preferred, the name of all persons arrested, the name of complaints, the offences charged against them, the offense so and so, depends taken their possession otherwise, and the names of witnesses who have been examined. The magistrate in the diary. So this section 41 just for the convenience, Your Lordship. Then here is quoted also section, but it is quoted here also, Your Lordship, 58. Then Your Lordship will say go to para 59, Your Lordship. It is pertinent to note that during the year 1861, when the aforesaid Police Act 1860 was passed, Code of Criminal 1860 was also passed. Section 139 of the code deals with registration, and this section has also referred to a word diary and so on. It referred to case diary, Your Lordship. Then next, then I take Your Lordship to para 64, Your Lordship. Para 64. These are all that I'm not required here. The general diary is a record of all important transactions, events taking place in a police station, including departure and arrival of police staff, handing over, taking over charge, arrest of a person, details of law and order duties, visit of senior officer. It is in this context, the gist or the substance of each FIR has been registered at the police station and is also mentioned in the general diary, since the registration of FIR also happens to be a very important event of the police station. Since the general diary is a record link that is maintained chronologically on the day-to-day basis on each day, starting with a new number 1. The general diary entry reference also mentions simultaneously FIR book and the FIR mentioned so and so. Your Lordship, then I take Your Lordship to page para 83, Your Lordship. Para 83 is at page, Your Lordship. At page 49, Your Lordship. Okay?
Page 49.
Para 83, Your Lordship. In terms of the language used in section 150 of the police is duty bound to proceed to conduct investigation cognizable offense even without receiving any information. It's very important, Your Lordship, about the commission of such an offense. If the officer in charge of the police otherwise suspect the commission of such an offense, the legislative intent is therefore quite clear, that is to ensure that every cognizable offense is promptly investigated in accordance with law. This being the legal position, there is no reason that that there should be any discretion or option left with the police to register or not to register an FIR when the information given is about the commission of a cognizable offense. Every cognizable offense must be investigated promptly in accordance with the law, and all information provided in the section 150 of the code about the commission of cognizable offense must be registered as an FIR so as to initiate an offense. The requirement section of the code is only that the report must disclose a commission of, this is important, commission of cognizable offense, and that is sufficient to set the investigation. So only thing is a cognizable offense has to be done. They have to do it. If there is no cognizable, then they never register an FIR. Then para 84, Your Lordship, see. The insertion of subsection C of section 154 by way of an amendment reveals the intention of a legislature to ensure that no information of commission of a cognizable offense must be ignored or not acted upon, which would result in unjustified protection to alleged offender or accused. Then I take your lordship to para 93, page 51, your lordship. The object sought to be achieved by registering the earliest information as FIR is entirely twofold. One, that a criminal process is sent into motion. This is important and is well documented from the very start. And second, that the earliest information received in relation to commission of a cognizable offense is recorded, and there cannot be any establishment or letter, your lordship. Then I'll take your lordship to para 95, your lordship. Next page, your lordship, para 95. The police is required to maintain several records, including case diary, as provided on section 172 of the code, generally as provided on section 44 of the Police Act, your lordship, I pointed out that, which help in documenting every information collected, spot visited, and all the action of the police officer, so that their activities can be documented. Moreover, every information received relating to commission of a non-criminal also had to be registered under section 150 of the code. Then next para 96, your lordship. The underpinning of compulsory registration of FIR is not only to ensure transparency in criminal justice delivery system, but also to ensure judicial oversight. Section 157(1) deploys the word forthwith. Thus, any information received under section or otherwise has a duty to inform in the form reported to magistrate. Thus, the commission of a cognizable offense not only brought to the knowledge of the investigating agency, but also to the subordinate judiciary. The next para 97, your lordship. The code contemplates two kinds of FIR. The duly signed FIR under section 150 or is by the informant to the officer concerned at the police station. The second kind of FIR could be which is registered by the police itself, on which on any information received or other than way by informant. Section 157(1) and even information, even if it has to be duly recorded, the copy of should be sent to magistrate for it. The registration of an FIR either on the basis of the information furnished by the informant under section 154(1) of the code, or otherwise under section 150 at signature. The obligation of so and so. Here, your lordship is there. Now I take your lordship to para 105, your lordship. 105, page 956, your lordship. My lord has got page 56. Therefore, reading of section 154 in any other form would not only be detrimental to the scheme of the code, but also to the society as a whole. It is also seen that the code has repeatedly held that various decided cases that the registration of the FIR is mandatory if the information given by the police under section would disclose the commission of cognizable. Then, your lordship, I take your lordship to last para, conclusion, then 119 page 60, para 119. Therefore, my lord has got it. Therefore, in view of various counter claims regarding registration or non-registration, what is necessary is only that the information given to the police must disclose the commission of a cognizable offense. In such situation, registration of FIR is mandatory. However, if no cognizable offense is made out on the information given, then FIR need not be registered immediately, and perhaps the police can conduct a sort of preliminary verification or inquiry for limited purpose of ascertaining as to whether a cognizable has been committed. But if the information given clearly mentioned that a commission of a cognizable offense, there is no other option but to register an FIR for it. Other considerations are not relevant at the stage of registration of FIR, such as whether the information is falsely given, whether information is genuine, whether information is credible, etc. These are the issues that have to be verified during the investigation of an FIR. At the stage of registration of FIR, what is to be seen is merely whether the information given is expressly disclosed the commission of a cognizable offense, if after the information given found to be false, and so proceeded. Now, next para, conclusion to 120 para. Here it sums up everything. In view of the aforesaid, we held that the registration of an FIR is mandatory under section 150 of the code if the information discloses the commission of cognizable offense, and no preliminary is permissible under such. Then says, if the information received does not disclose a cognizable offense, but indicate the necessity of an inquiry, preliminary inquiry may be conducted only to ascertain whether cognizable is disclosed or not. If the inquiry discloses the commission of a cognizable offense, the FIR must be registered. In case where Preliminary inquiry ends in closing of the complaint. A copy of the entry of such closure must be supplied to the first information force and not later than one. It discloses the reasons herein and closing of the complaint. Then the police officer cannot avoid, this is very important, cannot avoid the duty of registering offence if the cognitive is disclosed. Action must be taken against the erring police officer who do not register if the information received discloses cognitive. This is very important. Then 125, see the scope of preliminary inquiry is not to verify the veracity or otherwise of the information. This is very important. Receive but only to ascertain whether the information reveals the cognitive. Then at what type of which the cases of preliminary, so this is not mentioned, Your Lordship. So, Your Lordship, the Supreme Court, the judgment has clearly laid down, if a cognizable offence is made out, FIR has to be registered. And there is no discussion. And if police officer failed to register an FIR, he is liable for consequences for that. So, Your Lordship, here what happens, Your Lordship? Admittedly, a cognizable offence has been made out. On the basis of that season, another FIR was made, that is for keeping in custody of the drugs. That is the allegation, Your Lordship. So, here Your Lordship will see, it is clearly shows that the second FIR was lodged against the petitioner.
When second FIR was lodged?
That was 2010-2018, Your Lordship. Second complaint turned, I can put a second complaint turned into FIR. That I can put it that way. That's better, I think.
And first FIR was?
First, there's no first FIR. That complaint.
Date is?
3/8/2018. This is not FIR, it's a complaint.
So incident occurred on 3/8/2018?
Yes, Your Lordship. 3/8, this read petition is concerned only 3/8/2018. It's not other. Incident seizure memo is there. So non-registered FIR and involvement of police officers. These are three things. Involvement of police officer in the whole thing, whole episode, this thing, Your Lordship. And Your Lordship, drugs are, it is transported through Nagaland. It is coming from Manipur, Myanmar, and transferring to this. So state police do not have jurisdiction that side. And plus, they are involved in this thing. They are because the second, the FIR which has been lodged against me was to save the OC and the in-charge police station. Your Lordship. That is the charge sheet reflect that. They have been dropped as an accused later on. The OC was also made an accused in that investigation my FIR. And the in charge of narcotic cells, he also made it, but there have been dropped for other years that I'll do.
But in the second complaint which was lodged,
Yes, sir.
is there any allegation that they were prevented from, they were asked not to register the first FIR?
No, nothing. Nothing.
In the charge sheet also?
Nothing. Charge sheet has not mentioned it.
That you prevented registration of the first FIR?
Nothing. Your Lordship, in the suspension of
how the charge sheet which was filed against you,
yes, sir,
have dealt with the first complaint?
they have not dealt it.
They have not considered.
They have not. They have just they have put a document 5 only that thing. This part is not in.
How it was referred to?
It's not referred. If your Lordship will see, if I come to charge sheet later on, it will reflect that. Charge sheet doesn't consider about this thing. Your Lordship, the basic charges against me in my
That the drugs were found in your residential.
no, what happened? It was kept in my custody, not possession.
No, the allegation against you in the
this-
second FIR is that drugs were found in your.
No, drugs are not found. It's not found. It is not that allegation. It is said that drugs were there in the police station, Malkhana. I asked these police officers to give me the drug to be kept in my custody. That's the allegation.
That is the
Allegation. And what happened? This they have given me. That is they said I have given me the drugs. I also admit for keeping it safe custody because police. I was telling that there's no proper security, night security in the police Malkhana. Earlier there was loss of drugs from there. So that is what reason it was kept in my custody because I have 24 police security in my residence. Just for that. And
And police station does not have that security.
proper prosecutor, right security. That's why I was, because that's why these drugs were taken, but it is all allegations kept in custody, not possession. These drugs were kept in custody of my instead of Malkhana. That's the allegation. And so far, your lordship, the allegation made against me that I prevented them to lodge the FIR. I allowed this accused to go away.
Where this allegation has been made?
In the suspension order. Suspension, they have their case. They
The DP,
no, in
the
other
DP, in the criminal case?
yes, criminal case. Your Honor. In
No,
that
no.
FIR Act.
There has to be clear distinction.
Yes. But that's clear.
My query is,
Yes, Your Honor.
in the first instance, on 3rd of August, a complaint was lodged
Yes, Your Honor.
by the SSP.
SS, no, or to the,
by the
commander, I should to
Under
the SSP,
narcotic cells,
to OC.
OC.
Yes, sir.
OC is the superintendent
Yes.
of police
SSP,
level officer.
Investigative Police, just lost,
And on the basis of that, it was not registered.
no, they are not registered.
Is there any allegation later on that it was not registered because you asked not to register?
That is the allegation they have made. They have allegation.
Where that allegation?
That is in their, because what happened, after this incident happened, let me project my case. On 18, on my case is 18/8/2018. Since
You
they have
came to know for the first time.
first time.
That is your,
And they said this has happened. They said we didn't register an FIR. These people are let off this thing. That counter, all oral, they also made oral. I said these are the things. And 18, there's no dispute keeping in custody of the drugs. There's no dispute. They have also said that they have given on 2 dates, 6 and 17. Your lordship will see they in the charge sheet for the first time. Their allegation, I didn't allow them to make a diary entry. The charge sheet for the first time, there's no evidence. Charge sheet for the first time, they have stated that on 6th of August 2018 and 17th of August 2018, the drugs were taken, drugs were given to me, and there's a GD entry made on 6 and 8/17. That is subsequent. That came for the first time in the charge sheet. Nowhere in the evidence. Evidence doesn't say that. What I may point out to your lordship, what has happened? This date 6 and 17 was introduced later on to make up the case, your lordship, because that is not mentioned anywhere here. Because what has happened after this incident happened, that when it was reported to the DGP had asked them to make an inquiry, your lordship, and in the inquiry, all these police officers made the statement, your lordship. That is part of the record. The OC, all this, there no mention of dates are there. There's no mention of any dates, 6th or 17th that they said drugs were taken, this or that, no dates, few days. The dates, even in the memorandum of charges in my disciplinary proceeding, that they know there are no dates. The dates came for the first time when they made a section 161 statement in 2019, August 2019. That on this date, these drugs were given by some of the witnesses, these 2 dates. Your lordship, they don't remember the date in 2018, there's nothing, 2000, the dates are totally missing. 2019, first time 161 statement comes. Now what happened, your lordship? To substantiate a 161 statement, 4 police officers made 164 statement, confession, your lordship. 4 police officers, including SSP, IC narcotic cell, and the commander and another person. They made 161, various people have made. This out of this, four of them had made confessions in 164.
Confession.
Yes, confession against me, implicating me, not implicating. That's a peculiar fact of the day. 164, if a lordship sees, 164 statement can be made by accused. So far,
It can be made by witnesses.
witness 164.5. They can state that will be statement. That won't be confession. 164.5 talks of statement. 164.1 talks of confession. It is made by the accused voluntarily. 164, where it was.
But those 4 were not the accused.
Who?
This.
No, 2 have been made accused. 2 are accused. the SSP and the IC narcotic cell. They have been made accused. They have in the investigation they have been made and they have been discharged. They are discharged also. So their statement won't come on because that is the reason their statement won't come on 164.5. But the other two people will come because they are not accused. If they are accused, then they are 164.1. Confession will come. So these are the intricacies. 164.5, if you see, 164.5 there are confession. All statements are not confession, but all confession are statements, Your Lordship. These Your Lordship knows about it. So these two are that. So 164.5, 164 talk of statements. And statements is not, you cannot take what they are doing. They are relying on 161 and 164 statement to file the charge sheet. That's the peculiarity of the matter, Your Lordship. They have no evidence at all. If Your Lordship, may I take Your Lordship 164? 164.1, if you like it. Any metropolitan magistrate or judicial minister may, whether or not hear the judicial in the case, record any confession or statement made to him in the course of an investigation under chapter or law, time being in force at the time after sentence. Provided confession is recorded or then the magistrate say para 2, the magistrate before recording such confession, here statement is not there. Very distinct. Here confession. Explains the person making it that he is not bound to make the confession and that if he does so, it may be used as
It would
evidence
be
against
regarded as confession only if it implicates
Yes,
the
sir.
maker.
They have not implicated themselves.
Then it would not be a confession.
That's the problem. That is here whatever section 30 of the Evidence Act bar that under section 30 of the Evidence Act that can be used against me and that can be used as evidence. This confession is it should inculpatory and exculpatory. Confession cannot be that I am innocent and the other person is accused, have done everything. Their confession statement, if you see the record, they are only putting the blame on me. Nothing is on them. They are clean sheet. So that's why the section whether it's 161, there are two aspects of it. Whether your lordship will see if an accused make a statement under 160, if a person make a statement under 161, can it be substituted by 164 statement? That is also one legal issue. That cannot be done. 161 statement cannot be used in a further proceedings for only for the investigation. But that 161, you make the statement again and on 164. That may be by accused or by any other person. Can it be used? Can that bar can be overridden by 164 statement? That was done here. Because there was a section 1 to give more credence to that they made 164 statement, which they cannot do here. And if you confessional statement, if you see the confession, these are not confession at all. The procedure prescribed has not been followed also. That will come later on there when I go to a charge sheet matter here. So I'm giving so 164 is very important. 164, the material they don't have it. The oral statement which they make against the accusation, there's no material. They put in 161 statement, then 164. And on the basis investigation, but no material. And the worst part is your lordship, as a charge sheet which has been filed against me is only against keeping in custody of the drugs. Not against, not prohibiting them in registering FIR, all these things are not there. The main accusation, I didn't allow them to, that is not yet, that will be shown later on, your lordship. So charge sheet doesn't say that. Charge sheet is only, charge sheet is going on a different plane, your lordship. So your lordship, this 164, so I'm just coming with your this thing, no? So these are the basis, your lordship. No, now your lordship, since the investigation of this case did not consider at all the two documents, that is clear that they are trying to hide something. They don't want to investigate the matter because once they take this FIR into record, lot of heads will roll in, including police officers. So that's purposefully this was not taken up. And your lordship, this investigation cannot be done by the state police force because they are involved in it. It will be high rank police officer. It will ADG, additional director, all these people are involved.
How high rank police officers?
They are involved, your lordship. I've waited past allegation, everything is your records will show.
Now, apart from your allegation,
That is the, so, that's the FIR. I am prepared, let that FIR be a complaint, let me investigate against me, I'm not bothered. Then let this complaint be investigated by CBI, let them investigate against me also, I'm not shy on that. Let them investigate against me also. I'm not saying that they are, I said, if you want, you investigate against me also. In respect of complaint dated so and so, whether I am involved with that. I'm not trying this, I'm not saying that I am innocent in respect of, I'm not saying anything that I should be investigated. Let them investigate, let the FIR be registered, let it be all the police officers, again, including me, I don't mind. Including me. Let it be
but
investigated.
their plea may be that
Yes.
they have already investigated.
But this where the charge sheet doesn't show anything. Charge sheet is totally silent on this complaint.
Your submission is that
Yes, how the drugs has come to that position, it has
this
not been.
aspect has not been.
Not been said. The initial, how does this drugs has come into the position of the police station? That has not been explained anywhere. Once, suppose the drugs is not, how can I be accused keeping in the drugs?
Okay, and from whom it was originally recovered,
Recovered from the two, and
that
the,
has not been taken care.
no, and the best part is that two drug peddlers have been prosecution witness against me in the disciplinary proceeding.
No,
Yeah, I showed you.
no. For a moment, forget about discipline.
Yes, no, I just, why I'm telling you that the league is established that way, Your Lordship. I'll just show you that one page only, Your Lordship. I'm just, if Your Lordship turn to page 83, Your Lordship. This is their document. Page 83. My Lord has got it. Yeah, this is in the list of witnesses by whom the article of charge framed against Richard Imto, IPS so and so, are proposed to be sustained. This Remchamo P against him also allegation. This SSP. This is a complainant. 3 is complainant. 4 is in charge narcotic cell. 5 is the person who is the commander of narcotic cells. Then if you are 7, 8, Rahul Kharal, Deepak Lamba. These are the person, they have been prosecution against me by the department. So now the question is, they are saying, I let the accused go. If the accused, I have let them go, how they have come into contact again to make the prosecution witness? This order was taken from high ups to make the prosecution. They cannot be made like that. It has gone to a GGP level and that thing. So if my allegation against me totally falls to the ground, because they said I didn't allow them to register FIR. I allowed them accused to go. Then third, there is no DD entry has to be made. These are the 3 allegations. But if I have let them around, they were said they were restless and they went. But how they have come in the contact again? This is very vital thing. Why an independent inquiry is required? Because these accused are being protected by why you have not if they are in either why you have not registered FIR against these people? They are drug peddlers. You have not registered FIR against the drug peddler, but you have registered against for keeping the drugs in me. So the issue is if the chain is broken, if the initial drugs have not come to, how can I be in custody of mine? If there is no investigation that part. And that's the complaint. The drugs, the accused have been not done, nothing has been done. So I have been only in this whole thing, I have been accused, all these drug peddlers are all got scot free. So that cannot be done, Your Lordship. And moreover, Your Lordship, these drugs, because what happened on 1/9/2018, all these senior police, all these police, they went to my place. Instead of getting a receiver, they go for seizure again, they have a second seizure. Your Lordship, the issue is, can there be a second seizure when the item is with their custody? They have not stated that it has gone out of my custody. So 1/9/2018, they again seized this from my, they went for the, I said, these are the drugs, they take it. And there's nothing wrong in that. They said this is intact, they've taken it back. So now issue, Your Lordship, is, can there be a second seizure of the same thing? When there's a first seizure memo already in the record. Second seizure may be, that I'll deal with that other matter, Your Lordship. Second seizure memo cannot be done, Your Lordship. Only seizure memo will be done, Your Lordship, if the drugs have been stolen from there and then subsequently recovered. That can be second seizure. But here nothing is there. They say I have handed out to keep in custody. So where is the second seizure? There is no occasion for second seizure. In case there is no occasion for second seizure, there will be no occasion for registering the FIR also. In respect to that allegation, Your Lordship. If the drugs cannot be seized against from my custody, they have kept your statement is it's kept in my custody, not it is found in my possession. They're two different aspects. Drugs are not found in my possession. They didn't say they have got information that drugs were with so and so. You go against them. They say it is kept in, and they have admitted that we have given this drug to him to be kept. That may be separate offense, Your Lordship. But I cannot be prosecuted for NDPS. How can I charge for NDPS, cheating, misappropriation, prevention of corruption, all these things? That they have made the charge against me, that I'll deal with that better, Your Lordship. Now the issue is, how can there be a second charge? The second thing, if the second seizure memo is not tenable in law, then FIR also goes. FIR was filed on 2/2010 against me for seizure on 119. The first seizure got.
No, why second seizure cannot be made?
Second seizure can be made if it is out. It was in a custodial police station.
It was not in the custody.
No. It was kept in my custody. It is not a second.
That is the allegation against you,
No,
that
no.
you yourself took the.
No, that is their allegation, but nothing could be found.
No, what I understand
Yes,
till
sir.
now from your submission, you are a police officer of IGP rank
Yes, Your Lordship.
and the OC was SSP.
Yes, Your Lordship.
They have stated before the IO of the second case
Mhm.
that they were asked not to register FIR by you.
Mhm.
And they were asked to hand over the seized contraband to you.
Yes, sir.
And therefore, thereafter you took it to your residence.
Yes, sir.
So even if there was a first seizure made on a previous occasion, it was taken out of the custody of Malkhana. Therefore, second,
Who has given? They have given in custody. Your Lordship, this is very important. If it is taken out of custody without the aid of anyone, and it has been recovered, that can be second. Here, what happened? I may ask, the police officer came and gave it to me.
is there any document?
They have stated, Your Lordship, see, their allegation against me, just see. If Your Lordship will see, page 78, this discipline, the charges, Your Lordship. Page 78, Your Lordship. 25/10/2018. These are the charges on the base. My Lord has got it. Page 78.
Yes.
There was no general ID reference on the seizure GD dated 24th and 4th August 2018. 2. No criminal case was registered. 3. The two persons from whom
We have to segregate. This is regarding with the disciplinary proceeding. This is a disciplinary.
No.
You should confine only on the
No,
criminal
it's
aspect, not
not.
to confuse
No,
the
no,
court.
I'm
also.
not confused. I'm not confusing.
This is a disciplinary.
I'm showing it. Discipline, nothing has happened till today. Discipline, no, nothing has
For
happened. till today.
disciplinary proceeding, he is
Nothing
not
has happened.
approaching this
No,
court. He has.
this WPC is,
Yes.
here you have alleged
No, Your
that
Lordship.
FIR was not registered.
No, your Lordship asked me something that I want to show from the documents. Your Lordship asked, that is why I brought it here. Your Lordship. Otherwise, I'm referring only for this purpose. There are two persons from whom contraband says you released and the vehicle were released. This was the allegation also. 4. The seized contraband powder was kept in the personal custody of so and so IGP and not in a Malkhana narcotic. So this was the allegation, Your Lordship. And from the statement also, they said it is given to be kept in a Malkhana. It's not a. So that is not because now, Your Lordship, how can there be second seizure to the effect, Your Lordship? This aspect I'll deal in the other matter, Your Lordship. I'll just
Okay.
now
Now
what
assuming that
yes,
the first FIR was not registered.
yes, sir. Yes, sir. Your Lordship,
which I have to hear the prosecution
Yes, sir.
side also,
ah,
because they will say that it was not registered because you asked them not to
that's
register.
it. Judgment is clearly saying that. You cannot do that. Until today, no FIR has been registered. Your Lordship, 2510, I was suspended for that. Why till today now FIR is after I left the job, they are free to do that. Why they have not done?
On 20th, they registered the affair.
Against me, but 2510 I was placed under suspension. I am not IGP CID, so I am out of the picture. Then why the department didn't lodge an FIR register that complaint? Why what the reason that till today the complaint has not been registered? Today is 23, Your Lordship. Why this complaint has not been registered, Your Lordship, till today?
Then we have to see whether in the second FIR, which was registered
Yes,
on
sir.
20th,
Yes, Your Lordship.
whether these matters are covered.
No, not covered.
These were
Not
investigated.
covered, not investigated. I can show it, Your Lordship. If Your Lordship take the charge sheet, it's clear from the charge sheet that nothing has been mentioned about this.
Okay.
So
Okay.
I'll go to that because I'll get deviate from that. I'm just pointing out. It is
Okay.
not that I'll show Your Lordship to sir.
Okay, assuming that it was not registered.
No, it's not
and
registered
it
and it's not been investigated. That's
and
my categorical
It
statement.
is required to be registered and
Investigate.
then
yes.
why it should be investigated by CBI?
CBI because this see Your Lordship, two things are there. One, drugs is an interstate thing. It's interstate from coming from it is passing through Nagaland. Secondly, the involvement of police officers cannot be ruled out.
That is a speculative statement.
No, that is not that is clear. It's coming from there. Your Lordship, why you have made them why not resisting case against them when they are in a know-how?
Because their cases you prevented.
Hey, prevented, Your Lordship, my prevention is, I admit I prevented, but it was still 2510. And in the charge sheet, it's not there also that I prevented. Nothing has been said. Charge sheet, nothing has been said that I prevented them from registering FIR. And no charges has been framed against them on that aspect. No charges has been framed on that aspect. If I prevented them,
No.
that's an obstruction of that, another offense comes.
In
That charge is all not there.
in DP.
Yeah, no, in this charge sheet, this criminal case.
Okay.
Criminal case, there's no charge. Suppose, admittedly, I have done this. Where the investigation, there's nothing in that regarding that.
Regarding that,
Yes, only keeping in custody. They have prosecuted only for keeping in custody only. They're not nothing about non-registering FIR, all these things. There's nothing has gone into.
when you were suspended?
25/10/2018, Your Lordship.
Before that, the second FIR was registered.
Yes, second FIR was registered. 2010 is the FIR. Then after that, I was not in the CID department. I thought I had someone else has come. When this was within the knowledge of this, why they have not registered the FIR against this person? Now I'm not there. Suppose I prevented. When I'm not there, they can register in FIR. Why till today the FIR is not registered? That speaks lot volumes. Because FIR has to be registered. Because if the FIR has to be registered, Your Lordship.
Okay.
So 151 I showed, that's why they record, they take your that. Because if you suppose independently, suppose a cognizable offense has been weighed out, and that is recorded with you, and that's part of it. And if till today you have not registered an FIR,
Okay.
what the consequences will follow para 120, Your Lordship. So these are things, so that's why, Your Lordship, the moot question is this: why these are not why these people are being protected by the police officers? The FIR should have been registered, the investigation should have been done, which they have not done. And Your Lordship, these drugs were kept in the custody also, not in the court custody also. That is also another thing. These drugs from 1/9/2018 just taken from me till 5/11/2018, the drugs were in the custody of the police station. Only when I surrendered when I appeared before the court on 5/11/2018 to get a regular bail, it was pointed out to me that till today the drugs are in the custody of the police station here. It is on the order of the special judge. It was the officer deposited before the CJM on 5/11/2018. That's on record. So the drugs were kept in so many periods. Now during this, what happened to the drugs may have disappeared also. No one knows. The packet might have changed. So all this thing, because 102, your section 102 CRPC clearly says that you have to deposit immediately. There's violation of section 1. So if you are to see all this, the broader picture, it has to go for independent agency, your lordship. Section 102, your lordship knows. May I read that 103, your lordship?
No, okay, if the, otherwise FSL report is there.
Yes, sir. All that,
Showing
everything.
that it
Everything,
could be
everything is there.
heroin.
That I have to go right. I'll take your lordship to all those things. All those. Now your lordship will see this. So for CBI inquiry is concerned, CBI inquiry is a must in this case, because if they are innocent, they'll be innocent. Let it be investigate the matter. Because here the drugs has come, this all these things are interstate the narcotics trade is all the same. So CBI will be a better position in investigation, and independence is there. No interference from anyone.
And your submission is that this aspect was not investigated by the subsequent.
Yes, not investigated. That's not investigated.
This aspect was not
Not
investigated.
investigated. That is only part of D5 only. They put on record, document D5, volume D5, your lordship.
Without making any investigation.
No, nothing. That's only on the record. They put this because this is on the record. They put it in the record. They've not mentioned anywhere about this. No investigation in this. Had they made an investigation, if this FIR one.
And in the second charge sheet,
Yes, sir.
the only allegation is that you possess
Yeah.
heroin.
Yeah, yes.
Apart from possessing,
All the charges are on that.
is there any allegation that you prevented the registration of first FIR?
Nothing. Investigation, nothing.
Therefore, the first FIR was,
No, that's nothing. They have not gone to first FIR. There's nothing on that.
no,
They're totally
while
silent.
investigating the second,
Second FIR, they have not gone into it.
from where the heroin came,
Yes, they have not gone. They have only in the custody, ITC in my custody only that.
from where it came to your custody,
My lord has got the point. From where it has come, that not been investigated.
that was not investigated.
It starts from 1/9/2019, 18 that from Caesar to me.
Okay.
So that's the issue, your lordship. Now your lordship will see for the CBI investigation, there's a constitutional judgment also.
When CBI investigation can be directed?
Yes, sir. The judgment is that is your lordship 2010.
Yes.
3 SCC. Page 571. This is also 5 judgments. Here what happened, your lordship? The Calcutta High Court under 226 had exercised the jurisdiction to order an investigation by CBI. The state government has contended that without the consent of the state government, section 6 of the Delhi Special Police Establishment in 1946, it cannot be done. So that was rejected by the Calcutta High Court, and Calcutta High Court held that 223 you have independent power, court has independent power to go into those issues.
Okay.
And fire referred. So that matter was referred to Constitutional Bench of Judge, and Constitution has held the Calcutta High Court view only.
Okay, no, my query was different.
Yes, sir.
Here the court, what the judgment which you are referring,
Yes, sir.
held that the consent of state government is not
Not-
necessary.
Court has the power.
If the court directs
Yes,
CBI.
court has the power.
My query is under what circumstances CBI investigation may be directed?
Yes, that is why CBI recently, your lordship, this drugs were seized, they have not been.
No, is there any guideline why state investigating authority should,
There's no guideline, there's no guideline,
should,
there's no guideline. I take your lordship the judgment, is that deal with this thing. Your lordship, take para 20.
then why to overlook state investigating authority?
No, you have
There
to-
must be some,
Your lordship, state, in the affidavit, they have not raised any objection that they are opposed to the investigation. They have not said in their affidavit. So they have not take help us, they have not created section 6. They have not created section 6, but for section 6, because 226, court can override section 6. It's not, court is not bound by section 6 limitation.
no, okay, that aspect is okay.
Yes, sir.
But why to direct, why not to, if suppose this court comes to a finding that FIR ought to have been registered
Yes, sir.
and some aspect needs to be
Yes, yes.
investigated. Then why state police may not be
The
directed?
state police are, involvement of state police are there, your lordship. It's clear from the record. It's clear from the record. Involvement of state police are, senior police officers are there, your lordship. SSP is there, SPC also under the accused. Then all these people are there, your lordship. SSP is also there, your lordship. All these allegations are there, your lordship. So when it should be impartial inquiry, it cannot be a biased thing. The way this investigation, I'll show it from the record, also very evident. They totally shielded them people and put the blame on me. Because if your lordship see the statute, they are bound to register an FIR, your lordship see. Question is, an SSP, suppose if I say don't register, which you follow, are bound to follow. DC take a high up that so and so has prevented to register. DC take to the GDP that IGP has refused me to prevent. She is an SSP. She's not a sub inspector or something who is bound by IGP. She's an IPS officer. She can go to the DGP, sir, I will this so and so is refused. She can go to the high ups. She has not done. Why she has not done? She should have gone and complained to DGP on that day itself. So and so 30, so and so has refused to prevented for Eastern FIR and this thing, and he has led the accused free. If that was the allegation, there is no report to DGP by her. It is only on 25th of August the whole thing started moving. So that is the issue. These are the circumstances which lead to investigation by CBI also. That because here, if you watch the accused are all police officers, even I also police officer. The question is, it has to be by an independent authority. Let it be under supervision of the honorable.
Have you
Yes, sir.
stated in your writ petition
Yes,
that for these reasons CBI inquiry is
I
necessary?
stated. Lot of things are there. They are always. Your lordship. Your lordship, the page 27, your lordship, that's education starts here. The office of DGP Nagaland was pursued at the instance of Richard P. Kikon, additional DGP law and order, with malified intention in victimization petition of clearly appealed. See, so and so additional was instrumental in instituting a fake privilege case, which are only on the basis of contradictory oral statement made by some selected police officer, which could be found to give police protection to draft trafficking in the respondent state, in case the whole matter is illegitimate. The DGP Nagaland has given protection to this tainted police officer in respect of said incident on 1/9/2000 when there was alleged re-seizure of the contraband, had intention to avoid mentioning the name of so and so as his presence as if ADGP, as is reflected improperly and illegally usurpation of power of SSP so and so. The proper course of law to be followed by Srimati so and so was to produce both the arrested before the competent tribunal at Kohima, along with C-level suspected transfer, and 24 of the same so and so was required under law to deposit the seized material in the judicial custody of the competent instead of keeping it in our custody. See, Narola's office so and so handed over seized 11 packets of suspected amount through the IO to CGM Kohima only on 5/11/2018 on the basis of instructions of the principal district sessions and special judge NDPS Kohima. It is then admitted that the seized 11 packets of suspected amount was in the custody of OC respondent from 1/9/2018 to 5/11/2018, handing over the key of Malkhana to ransom for reasons best. There is a record to show that key of the Malkhana was the ADGB, and that's a record also. There was no reason as to why Srimati Narasa respondent did not produce the aforesaid measure before the special judge within 24 hours on 21/9/2018 also. These are the seriousness on the part of so and so, which has to be overlooked, which has to be for reasons based on that. It is interesting to note that the respondent has made the accused drug peddler Rahul Khara and as the prosecution of the respondent, which clearly pointed to the involvement of this police officer in the illegal drug syndicate operating in the state, or the patronage area. In case the matter is just surfaced, the president is investigation by some independent central agency, the real conspiracy of the whole would come into forefront and expose the person high ups involved in patronage illegal flourishing trade, drug trade in the entire North respondent state. The petition source was your. So your lordship, it has been stated, clearly stated, your lordship. These are basic reasons, your lordship. Because otherwise, the whole conspiracy has not come out. From where the drugs have come, that is not been investigated. How the drugs have come? From what are the sources? The main sources are not been tapped. The end point has been catched. So that's why CBI inquiry is required, your lordship. The drug trail is not originated from Nagaland, it originated from some other state, your lordship. It is coming from Myanmar, Nagaland, Manipur area, traveling to Assam also. It is on the transit to stop the vehicle. It was transportation of the drugs by these 2 drug peddlers have been caught. So your lordship, that's to bring out the real culprit in the book. CBI inquiry is required, your lordship.
And whether those 2 drug peddlers were named as accused in the subsequent charge sheet.
Nothing. They are not there. Only SSP and this IC narcotics cell.
SSP has been made accused.
Has made an accused in a loose sense. There's an acquittal, nothing has been at the last, no evidence they find because so they have been accused has been dropped. Only SSP and OC, this HR narcotics cell. 1K Angami and Narora Sophie, SSP. They have been made accused. Not this drug have not been made accused. From where the drugs have come, that has not been investigated.
Now, what stage trial is pending in
No,
the
it
second?
is a charge sheet has been filed.
charge?
They filed the second charge, first charge sheet they have taken.
Okay,
those
now,
things are there.
that is subject matter
That
of
is
this.
that other matter.
I'm
so-
just putting a query.
Yeah.
Yeah.
It is
The-
pending.
At what stage? It is
Charge
not,
sheet been filed because of the question print of.
stay is not there.
Stay is not there.
So it is proceeding in the.
No, it's not proceeding yet because of the pending of this matter, they're not proceeding. And I think stage, because that time what happened here also, the court has either it will be disposed of admission stage. So that's why we need the admission stage will be finished, but that continued your lordship. So that's why the occasion didn't come. I think we should take a stay of the proceeding also now, you before your lordship. Unless if your lordship is hearing the matter, that stay is not required now. Because the question, if the hearing is done there, because it was an admission continued for a long period, right?
Okay.
That's the reason for unless I think just because of that. And he's not running away from here. He's in a rank of IG, and he's due to return 31st of December. Due to retire in 2008 this year, 31st. And you only 1.5 months remain, 2 months, 2 months service still remain. So so your lordship will see that is the reason why CBI inquiry, how the drugs, why the drugs are, the transportation, all these things has to gone into your lordship, which has not been gone with the state police also.
Okay.
Then your lordship, the judgment, Supreme Court judgment on this CBI inquiry, your lordship, 2010, 3 SCC 571.
Yes. Where the Supreme Court said that
I can,
consent of state government
yeah,
is
I'll
not.
go to, I'll take to lordship to para 20 your lordship. 20.
You've given a copy of that judgment.
Your lordship.
Have you provided copy of that judgment?
No, this Supreme Court judgment.
Have you provided?
No, I know that SCC have given 2010, 3 SCC. That I given the book list is not there.
Yes,
My lord has got it.
yes.
It is 583 page, para 29. The word question issue which your lordship has spoken. It is manifest that in essence, the objection of appellant to CBI role of police in a state without his consent proceed on the doctrine of distribution of legislative power as between the union and the state, particularly with reference to the 3 lists in the 7th schedule. to the constitution and the distribution of powers between the state, three organs of the state. Next para. In order to appreciate the controversy, a brief reference to some of the provisions of the constitution will be necessary.
You are reading para?
Your Lordship, I'm reading at page 583. I start 583. Bottom para 20. Page 583. Your Lordship. I'm sorry, Your Lordship.
Yes.
Page 83. Para 20, Your Lordship.
Yes.
It is manifest that in essence, the objection of the appellant to CBI role in police investigation in a state without its consent proceeds on the doctrine of distribution of legislative power as between union and the state legislature, particularly refers to the three lists in the 7th schedule of the constitution and distribution of powers between the state, three organs of the state. Next paragraph 21. In order to appreciate the controversy, a brief reference to some of the provisions of the constitution would be necessary. The Constitution of India is divided into several parts, each part dealing with detail in different aspects of the social, economic, political, and administrative. For the present case, we are mainly concerned with part 3 of the Constitution, which enable the fundamental guaranteed by the state, primarily to citizens, and in some cases to every resident, and part 11, therefore, which pertain to relation between union and states. They have discussed it. Then I take your lordship to para 34 also. This discussion I will skip it. Para 34 your lordship. Page 587. All this entry they have discussed that your lordship I am skipping your lordship. Section, my lord has got page 580 para 34. Section 5 of the Special Police Act empowers the central government to extend the power of jurisdiction of the special police establishment to any area in a state, not being an unit area, for the investigation of any offense or classes of offense specified in the notification under section 3, and on the such extension of jurisdiction, a member establishment of the establishment shall discharge the function of a police officer in that area, and shall, while so discharging such function, be due to be a member of the police force or that area invested with the powers, function, and the privilege subject to liability of police or belonging to the police force. Section 35, that's section 6. Consent of state government to exercise. Nothing contained in section 5, your lordship, shall be deemed to enable any member of Delhi Special Police established to exercise powers and jurisdiction in any area in a state, not being a unit or a railway area, without the consent of the government of the state. Thus, section 5(1) empowers the central government to extend the powers and jurisdiction of members of the Delhi Police Establishment to any area in a state, but section 6 imposes a restriction on the power of the central government to extend the jurisdiction of the state establishment only with the consent of the state government concerned. In para 36, having noticed the scope of amplitude of section 5 and 6 of the Special Police Act, the question for consideration is whether the restriction imposed on the powers of the central government would apply mutually to the constitutional code as well. This is important. As stated above, the main thrust of the argument, say KK Manipal so and so, is that the course of adopted by the High Court in directing CBI to undertake investigation in the state of West Bengal without the consent is incompatible with the federal structure and also doctrine of separation of powers between the three organs of the state embodied in the Constitution, even when the High Court on material before it convinced the state police was dragging its feet for the investigation and so and so. Your lordship, then I take your lordship to your lordship. Then I take your lordship to para 51. Para 50 is page 593, your lordship. The Constitution, my lord has got it, para 51. The Constitution of India has expressly conferred the power of judicial review on this court and the High Court under Article 32 and 226 respectively. Dr. B.R. Ambedkar described Article 3 as the very soul of the Constitution, the very heart of it, the most important article. By now, it is well settled that the power of judicial review vested in the Supreme Court and in the High Court under Articles of the Constitution is an integral part and essential feature of the Constitution, constituting part of the basic structure. Therefore, ordinarily the power of the High Court and this court to test the constitutional validity of legislation can never be outstepped, even abridged. Moreover, Article 13 of the Constitution not only declares the pre-constitutional laws as void to the extent of which they are inconsistent with the fundamental rights, it also prohibits the state from making any law which either takes away totally or abrogates part of the fundamental right. Therefore, judicial review of the imperial council by virtue of Article 13 is read with 226, 32 and 226 of the Constitution, Your Lordship. Then I take your Lordship to para 53. Next page, Your Lordship. It is pertinent to note that Article 32 of the Constitution is also contained in Part 3 of the Constitution, which enables the fundamental right and not allow other articles of the Constitution which define the general jurisdiction of the Supreme Court. Thus, being the fundamental right itself, it is the duty of the court to ensure that no fundamental right is constrained or abridged by any statute or constitutional provision. Moreover, it is also plain from the expression in the nature of employed in the clause 2 of Article 30 that the power conferred by said clause is in the widest term and not confined issuing high prerogative writs specified in this clause, but includes within this MP the power to issue any direction, orders, or writs which may be appropriate for enforcement of fundamental right.
Okay.
Yes,
Okay, otherwise this judgment says that state government's consent is
not necessary, Your Lordship. Then there's a Gauhati High Court judgment also, following this judgment, that Justice Ujjwal Bey, when you were there.
Now, have you reached halfway mark?
I think I'm finishing this matter, then I'll go to. I'll take some time, then I'll go to the other matter.
Our time for today is over.
So we will do it, VC will do it for VC. there's no problem. VC.
Yes, Ms. Sokre.
Whether your lord will be sitting on 30th of October
No, that is a holiday for.
Holiday.
We'll be-
What is holiday?
or,
Till
On,
fifth,
on
fifth,
6th, it
Sixth.
is reopening.
okay.
6th of.
So you suggested that both of you.
Let it be after the holidays. itself.
No,
no,
there
yeah,
has to be a
Any- Any
fixed date.
fixed date, Your Lordship, see. Just check my diary.
Because I think 2 more hours minimum would be required. Because you have not yet started the other,
Other matter, yes.
and can it be separated from other 2? No,
These are interconnected.
Inter-
The documents will come by.
Because your lordship.
Because there has, Your Lordship, there has to be 2 separate judgments. Judgments to separate, because one is appealable, one is not appealable.
You have heard him much. So from his submission, whether the this court can quash the charge sheet or and the FIR. That's all, your lordship. Only after hearing my submission, your lordship. But if I submit that, his case will be totally different, your lordship.
Nine November. also. 9 November. It is a Thursday also.
it has to be at 2 p.m.
Okay,
Yeah.
your lordship.
Heard Mr. P. Chaudhary, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned public prosecutor Nagaland. The hearing remained inconclusive. Learned counsel for both the parties submits that the hearing may be continued through video conferencing mode. Hence, let this matter be listed on 9th of November at 2 p.m. through video conferencing mode.
Yeah, I should be there on 19 Gauhati.
Then you may be there, she has
When I
to be.
see that video, that's I said. Deeply obvious, Your Lordship.
Next time, let's finish it once.
I also did that. I also did that. I also did that. I got fed up. So.
You take one again,
This will take time.
No, no, no.
It will take.
This, because this one, you're almost finished.
Almost.
Oh, some research again. And after, I think we're trying to make it within this, because we will be having 2, 3, 4, 2.5 hours only we have now. So you're trying to finish your.
I'll try.
Within 1 hour. Then after that, I'll submit, and after that, you may reply now. So let's.
I'll try.
And let's finish.
I'll try.
Okay, I'm.
Thank you.
Okay.
Thank you.
After this, not
This one also book. Latest. Where is the file? Inform my chief of the order. And something back.
Thank you. I allow the BBC. Statement. Yeah.